In 2016, John Rossley was expelled from Drake University based on a rape complaint filed with the school by a female student. The only problem? According to her testimony, he was unconscious and thus incapable of consent. Trump's administration will be looking at how Obama's Dear Colleague letter has created situations where victims are labeled perpetrators. The Trump administration appears ready to take the first step toward unraveling the web of abuse surrounding allegations of sexual misconduct on university campuses. According to Trump administration Signals the End to Campus Star Chambers, written for The Federalist by Ash Scow, at a National Association of College and University Attorneys Conference in Chicago this week, Acting Assistant Secretary of OCR Candace Jackson said the Trump administration would take a less confrontational approach to the way the department handles accusations that schools do not properly address sexual assault complaints. The proposed changes include ending certain practices, namely, treating every complaint as a fishing expedition for violations, publishing a list of schools under investigation, an embarrassment tactic, and issuing sub-regulatory guidance to be enforced as binding mandates, like the Dear Colleague letter, which Jackson says could be considered for reversal. Sub-regulatory guidance refers to policy made by government departments and agencies rather than passed into law by legislators. What does this all mean? To understand, we must look at the current situation. Dear Colleague, published in 2011, made use of a system which has been exploited for decades by ideologues in the Department of Education to enact mandates that haven't been vetted by elected officials, but can be enforced with the same power as law. How was this done? Section 431D, subsection 1 of the General Education Provisions Act allows Education Department policies to become regulations by a kind of default process. Policy is transmitted to Congress 60 days after its creation. If Congress does not disapprove within 45 days after that, it becomes regulation. In other words, if they don't say no, the answer is presumed to be yes. This has allowed the Department of Education to repeatedly tweak Title IX of the Education Amendments of 1972, originally passed to end the practice of gender-based quotas for certain areas of study which women had previously often used for prestige rather than profession, a behavior which had pretty much died out by 72. By 1979, compliance with the law had led to academic environment changes which made Title IX enforcement outside of a civil court obsolete. The department responded by adding to it to justify a continued hands-on approach, expanding the law's coverage to the degree that quotas have been reintroduced in some areas to the detriment of male students. Dear Colleague was, at first, made policy the same way, by rubber stamping via lack of congressional attention. It attached compliance with its stipulations to post-secondary institutions' access to federal funding. It cited feminist-influenced research promoting feminism's discredited rape culture theory as a reason to update existing Title IX's guidance, including the Clery Act's documentation mandate with new campus sexual misconduct response policy, thereby attaching all of its mandates to feminist beliefs about human sexuality. It deems schools' grievance procedures for student and employee sex discrimination complaints subject to federal government oversight from that feminist-led perspective. And with that perspective established as the policy's basis, schools are required to have a trained Title IX coordinator, and all students or employees must be notified of who that is and how to contact that person. If a complaint is filed with a school on a student's behalf, regardless of where the conduct occurred and regardless of whether it's filed by the student or someone else, the school must process the complaint in accordance with its established procedures. The Title IX coordinator is in charge of that response. The school must investigate the complaint, even if the complainant asks that the complaint not be pursued. Schools must provide training to all staff and students regarding harassment and sexual misconduct. A student accused of sexual misconduct must be tried on a preponderance of evidence standard. This may be done without a lawyer, without the right to present any witnesses or evidence for his side of the case, and without the right to question his accuser. And even if he wins that hearing, his accuser may appeal and put him through it all over again. While some aspects of this are left up to the school according to the text of the Dear Colleague letter, it's described under that threat of an Office of Civil Rights investigation if the accuser complains of dissatisfaction with the proceedings. The guidelines are designed to allow accusers the ability to railroad through at school accusations which would not hold up in court due to lack of evidence. Dear Colleague also increased the list of offenses that universities must report among statistics on campus crime. In other words, the guidelines are nothing but a false accuser support system with a built-in stat counter to assist in the manufacture of evidence for their own support. If the details themselves don't make that clear, just look at the many entries in the Title9forall.com database, where you'll find cases like that of the Amherst College student who became blackout drunk while in the company of his girlfriend's roommate. The roommate performed oral sex on him, after which she found herself friendless due to her behavior. 2 years later, befriended by victims' advocates, she filed a sexual assault complaint against him with the college. The college's investigative panel excluded exculpatory evidence and expelled the accused. John Rossley's case out of Drake University in Iowa is similar. While blackout drunk due to an interaction between medication and alcohol, John was sought out by a female schoolmate who accompanied him back to his fraternity and initiated oral sex, details she admitted during the hearing, which occurred after she accused him of sexually assaulting her. During the extremely biased process, the university failed to consider and accommodate John's multiple communication-related disabilities and used his resulting difficulty communicating against him, excluded exculpatory evidence and witnesses, and refused him equal representation by advocates to that which his accuser was allowed during the hearing. John's father, an alumnus and trustee at the university, reached out to the Board of Trustees to ensure equal and fair treatment for his son. When he persisted, bringing up the Americans with Disabilities Act and the discriminatory manner in which the case was being handled, he was first ordered by the other board members to stop, then later asked to step down from the board, and finally voted off by the other members, essentially fired in retaliation for defending his son's right to a fair hearing. Certain elements of these cases, exclusion of exculpatory evidence, exclusion of witnesses, denial of equal advocate representation, and findings that are in contradiction to even the permitted evidence, are common threads that run through numerous Title IX sexual misconduct cases which have resulted in discrimination lawsuits filed by falsely accused men against colleges and universities across the United States. So, would reversing Dear Colleague fix the problem? Well, no, not exactly. It's a start, but there's more to be done than just that. Dear Colleague was the first part of a 1-2 punch. The second, called the Campus Sexual Violence Elimination Act, or Campus Save Act, was initially submitted to both the House and the Senate in 2013. It appeared to have died in committee, making it look to anyone who fails to investigate further as though it is nothing to worry about. So why is it? Well, it was slipped into the Violence Against Women Reauthorization Act of 2014 rather than submitted on its own merits, and as the act inevitably passed, it essentially codified the Dear Colleague guidelines into law. This has led to new gender studies graduate jobs, the creation and distribution of materials for Campus Save Act training. Ash Skow's article mentions the National Center for Higher Education Risk Management, which, as she pointed out, has thus far made millions selling a model to schools to railroad the accused. But this is not necessarily always a standalone thing. Everfi, for instance, is a donation-funded company that produces training materials for various institutions on various topics, including things like money management. Now, among those materials are training materials for compliance with the Campus Save Act. The good news is that the Office of Civil Rights is poised to stop pressuring universities to violate students' civil rights. The bad news is academic staff are now accustomed to doing so, and their now trained behavior is supported by the law, which offers the same guidelines. It creates the same model. So in order to get rid of the requirements and the environment they've created, the Campus Save Act must also be repealed, and the entire system must be replaced with guidelines encouraging the protection of accused students' due process rights in instances where significant penalty may be applied, as well as reliance on actual law enforcement rather than campus cops when a criminal accusation is made. President Trump appears open to this type of change. This can be done if people in the movement are willing to contact the president and their state legislators to encourage them to do it. If there's ever been a time for the men's rights movement in the United States to make its voice heard, it's now. In fact, it is essential, both to encourage reform and to ensure that the president and legislators actually follow through. With bias on both sides of the media, the vigilance of the voter is our best hope to keep politicians on the task of defending our basic rights and freedoms. Hello, everybody. This is Hannah Wallen, and welcome to the discussion portion of HBR Talk. Today, I'm joined by Aidan Paladin, Anna Cherry, and the adorable Spectre of Death, Prim Reaper, to discuss the United States Wrestling Federation's pending kangaroo court smackdown. I mean the Trump administration's interest in revisiting the federal government's approach to university policy on sexual misconduct. All hail Kekistan.
If you're listening to this after the live show and you want to hear the full stream, go to www.honeybadgerradio.com for our unabridged podcasts, or look up to the right of this video. There's a link to go directly to the unabridged version on YouTube.
As a professor, your hands are kind of tied in this. You can see this shit happening in your classroom with students who are doing this stuff. There's nothing you can do. Title IX, yeah, I don't have any answer. I'm just saying, like, oh shit, like there's nothing we can really do as professors to help with. We can see it happening, which is really puts professors in the best, potentially one of the best positions to help these students or to help work this stuff out to make sure that this kind of these false accusations, I mean, they're going to happen, but to at least try to work it out. We can't do anything about it, though.
Let me see if I understand this right. So you mean if you're aware that an accusation is false because of things that you have seen in your classroom, mm-hmm. you can't do anything about it because of
Nope.
Title IX?
Nothing. I cannot even tell a student's own name to their parents. Do you understand? Like if a parent emails me and says, this is my child, unless they've signed off on a certain form, I can't even confirm that that is their child. Like that is the extent that Title IX goes to. It is extremely restrictive. If I saw and had proof, I could not say anything, and I couldn't even report on it.
That's quite a departure from its original purpose, because it's the only thing that law was created for in the very beginning was that to deal with that situation of quotas, and those mm-hmm. quotas existed because, like I said in the intro there was the situation where upper class women would get degrees in certain areas of study, not to go out and work in that field of study, but to have it as a feather in their cap. Brian, you are a fairly recent graduate as well.
Yes.
What was your experience with university?
Well, I didn't see, because at the time I was still really new to all this like Title IX stuff, but I do remember distinctly, especially in the later years, there would be announcements made to new students every semester, and old students that had been there a couple of years, where they would go into the spaces that the students tend to occupy, the public ones, like the lunchrooms and like the large study halls and stuff, and they'd bring people from the administration, would bring police in with them, and they would talk about, essentially they would spread like these sort of rape culture statistics, like the 1 in 4 and the 50%. I don't know if you know the 50%, but it's the there was some study done where men were asked if they could I guess kiss or touch a woman and there would be no repercussions, would they do it? And I guess 50% of them said yes. And so they said, well, that means half the guys in this room, are probably predators, and you should be aware of it. I mean, they would literally do this, and essentially planting the seeds of distrust and fear in the women, and essentially a sense of self-loathing and white knighterry in men at the same time. Because, when you do that, the men in the room, they're all thinking, well, I'm not that guy, but I bet all these other guys probably are that guy.
The overall idea is we need to obviously stop legislating as much as we do in the Western world, in the US in particular. That was a weird thing to me, and still is, moving from Eastern Europe, whatever, Russia, to America, and seeing just how legislative everybody is, how much everybody likes to sue everybody else, how much the legal state sort of thing is involved in everything. That was weird to me. As you think in communism, the state is involved in everything and the government is involved in things. No, in Russia, the government doesn't have ability to come in and take your kids away because somebody said you're doing something wrong to them. Like I can't even, I'm not going to start with the issues that are brought about by ability to just legally sue anyone and to have different legal rights for people depending on their age versus this. There's just too much shit there. And that's why we have such a thing as you were describing, where you can't even give a parent their child's name because it's illegal. It's not secure enough. It's not, at a certain point we have so much security that things become insecure because nobody can get into them. They're too secure. So that's sort of along those lines. We keep having a runaway train and avalanche situation where people are just, the professors, the media, the grown-ups are sitting back a bit, and they're seeing these tantruming insane children, which is sort of the SOCJUST movement, the SJWs, the Tumblerinas, the radical feminists. It is children having a tantrum. And what we keep seeing adults do is step back and go like, well, I guess if nobody's stopping this tantrum, it must be legitimate, I guess. And they're just waiting for someone else to step in and stop the tantrum. And whenever someone does step in and say, enough, you're not going to go further than this because it's bullshit. You're taking people for a ride. You're taking advantage of people. You're using your victim status to actually be a victimizer. Stop. And so when that happens, then everybody goes like, oh, yeah, you're right. They are just a bunch of bratty kids and we should spank them into place. But they need that one daddy. They need that one leader, that person, that somebody to go, no.
One thing that I've noticed that is a very effective way of spreading ideas is memes. If you guys can make somehow, memes seem to get the attention of anyone involved with in the political sphere, in the alternative media sphere, even the president himself. I don't know if you heard, but there have been recent developments involving him retweeting a meme. So it would take some creativity, but I think that there would be a way to perhaps also send the message of why the Title IX thing needs to be removed, where it came from, why it's bad for us, and why Trump has an opportunity in his legislation to do some real good that I think would be very difficult for people to criticize if he moved forward with it. And maybe that's the way to get his attention, or at the very least get other people on the internet's attention to start to discuss it. I think memes can be extremely useful. Don't neglect the power of meme magic, is what I'm saying.
The Office of Civil Rights, their job is to make sure that there is not discrimination taking place. If the person who files the complaint with them is the accuser, then that's the person that they're going to advocate for. If you find yourself in a situation where someone has made an accusation against you, the minute you see your due process rights violated in the least, the minute that you are told you can't have an advocate, the minute that you are told, don't bring your parents, even the minute you're told, well, your evidence isn't going to be entered into the case, you file a complaint with the Office of Civil Rights. Don't wait for the outcome of the case, because you have as much right as a man. You have as much right to have the Office of Civil Rights defend your rights as a woman has for them to defend her rights. And in this situation, yours are the ones being violated.
I'm going to go ahead and close it out, but before I do, let me say thank you to Hannah for writing up the pre-written thing and also hosting the show. And I want to thank Prem, Anna, and Aiden Paladin for giving up some of their personal time to come and join us on this topic. You guys make this so spicy. So spicy. It's like curry. And I love curry. I had curry for dinner. So, with that said, I guess we're going to take off. If you guys want to, please subscribe, like, share. We normally do this show on Honey Badger Radio, but unfortunately, due to a bullshit copyright strike from a 3-year-old ad for a Elliot Rodger video, we cannot do live streams for the next 7 days while they essentially examine the claim against us to see if they can reinstate our streaming powers. So until they do, we'll be doing it on Karen's channel, but Honey Badger Radio is still there. We'll be putting up pre-recorded content as well, so please go there. If you're not subscribed to Karen, I don't know what the fuck is wrong with you. You should have been subscribed to that channel anyway, but because it's got lots of great stuff on it. So, and also, shit, why not subscribe to Prim Reaper and Aiden Paladin and Anna Cherry, because they also make good content on their own respective channels. So you have lots to listen to.
If you like Let's Plays.
If you like Let's Plays, sexy Let's Plays though, sexy Let's Plays, right? And your
Elfears are always sexy.
Always on Twitch. And yeah, they all have good content, and they're all wonderful ladies. So we will talk to you guys on the next stream, whenever or wherever that may be. And for those of you who had nice things to say about my recent diagnosis, I want to say thank you for your support. And I am humbled by how much people have come forward and said really nice things. I think that I'm going to be able to beat this, and I have you guys all to thank for it. So we'll see you later. We're going now to the after show. If you want to be an after show visitor or participant, please go and become a patron, and you can join us in the after show. So until then, we'll see you guys next time.